At the stroke of the midnight
Question
hour,
is whether you want to be you or everybody
I
else.
still have a dream. Patria o muerte.
Since the commencement of the Constitution of India, there were numerous instances of reports by the newspapers, the other mainstream news channels that there was conflict in relation to the central government trying to exert influence on the legislative matter of the state through the office of the governor of that particular state, which is the constitutional head of that state appointed by the government of India. Now, recently in the state of Kerala, you would have came across the charges and counter charges by the governor and the members of the State Council of Ministers in such a way that the governor is performing unconstitutional activities. The governor says in the counter allegation that the State Council of Ministers headed by the Chief Minister, they are not performing the constitutional duty of the matters pending in the legislative aspect to the governor of that particular state. So the issue has become very serious. So in this particular session, we would be discussing the recent development in which the Supreme Court has decided to look into this matter of the state government and the governor dispute or conflict of interest in relation to the long pending delayed legislative process. So welcome to ClearIAS. We will see the constitutional aspect of this particular issue. Can the governor keep the bill pending indefinitely? Can the governor reserve the bill to the President of India? Can the President keep the bill indefinitely without providing the proper response? Is there a federal provision in the Constitution of India? And which constitutional provision guarantees the powers, the autonomy for the state? So these will be the questions that we will be addressing in this particular session. So once again, welcome to the explainer session of ClearIAS. Now, before understanding the provisions of this particular issue, we will have to understand that the Constitution of India guarantees a federal polity in the sense that there is a union government at the center. At the same time, there is a state government which has got its own constitutionally guaranteed autonomy in its legislative matter. At the same time, we will have to understand the script of Article number 1 of the Constitution of India, which says that India, that is Bharat, shall be union of states, which means that we have not used the term federation in the script of Article number 1 of the Indian Constitution, and what is being used is that it is a union of states. Now, what does this indicate to? See, this indicates that unlike the American Federation, so American Federation is regarded as one of the classic federation. So unlike the American Federation, Indian Constitution is not the result of an agreement. So United States of America has established after certain number of states, they were economically backward, there were socially backward states, there were educationally backward states, there were militarily backward states. These states came forward and they have signed an agreement and decided that we will share the power with the federal government so that the state government will have almost equal power with that of the federal government of United States of America. It was on the basis of this consensus that these states have signed the agreement and the United States of America has got established. Now, the Indian Constitution is different. Why? Because we does not have an agreement. Say, for example, the state of Kerala, the state of Tamil Nadu, they have not signed an agreement to form the Union of India. And that is the reason why in the Constituent Assembly we have decided that we will not use the term federation in the Constitution of India, and that would in a way keep a misconception to the people of the world that if we use the term federation in the Indian Constitution, that the people would start thinking that it resembles the American Constitution. So we are different. And what is the difference? The difference is that in India, there is no agreement, as well as in India, the states are not placed on an equivalent platform or equal platform with that of the center, which means in India, the center has got more power in comparison to that of the state. So two reasons can be put forward for the reason or for checking the reason why there is no use of the term federation in the Constitution of India. One is that we are not formed as a result of an agreement as what we see in the United States of America. At the same time, our central government is more powerful than the state government. At the same time, we'll have to go to article number 246 of the Indian Constitution, which needs to be read in relation to the schedule number 7 of the Indian Constitution, which provides for 3 lists: union list, state list, and the concurrent list. Union list provides for certain number of subjects, say for example, banking, currency, foreign affairs. So these subjects gives the exclusive power of legislation for the Parliament of India. At the same time, there is second list or list 2, which gives the legislative power for the state legislature. And of course, there is a list 3, which provides for the legislative power for the center, that is the Parliament, as well as the state legislature. That does not get matter here. What you need to understand is that the state is given autonomy. At the same time, more powerful entity is the union government in relation to the state government. Now, here is the importance of the office of the governor. You may understand the concept of holding together federation. So United States of America is altogether a coming together federation, which means that the states have came together, they have pooled their sovereignty, they have signed an agreement, and the United States of America has formed. But that is not the case with Indian Constitution. That is not the case with Indian polity. We have a strong central government, and it is the strong central government keeping together or holding together the states through the office of the governor. At the same time, understand that article number 246 provides for autonomy for the states also in the legislative sphere. Now, it is important to understand the present scenario, the present case, the present Supreme Court observation regarding that the Supreme Court will check into the constitutional matters, the legal matters, whether the governor can pose indefinite delay in the legislative provisions of the state. Now, article number 200 becomes very, very important here. Article number 200 provides for the provisions of the governor, the ways by which the governor can respond for a legislative action of the state, in such a way that suppose if a bill is enacted by or bill is passed by the state legislature, that bill will become an official act only with the assent of the governor of that particular state. So as per article number 200 of the Indian Constitution, the governor has got 4 options. Number 1, the governor can give assent to that bill. That means the governor, once giving the assent to that bill, the bill will become an act. If the governor does not give the assent, technically it is known as withholding the assent. If the governor does not give the assent, the bill will get lapsed. The third option is that the governor can return the bill to the consideration of the state legislature. And the fourth option is that as per the discretion of the governor, if the governor feels that certain bills goes in violation of the provisions of the Constitution, certain bills goes in violation of the directive principle of state policy, certain bill goes in violation or certain bills subverting the authority of the respective high court, as per the discretion of the governor may reserve those bills to the consideration of the President of India. Now, what can the President do? The President may give the assent, The president may withhold the assent. The president may ask the governor to return the bill back to the consideration of the state legislature with certain recommendation. And if the state legislature is including the recommendations of the President of India and sending back to the bill to the President of India, it is not binding on the President of India to give the assent to that particular bill. Now, two provisions, that is the provision which give the power for the governor to withhold the bill, as well as the provision which give the power to the governor to reserve the bill for the consideration of the President of India, will actually delay the process of legislation which needs to be performed by the state legislature that is consisting of the members elected by the people of that state. Now, these are the reasons for the conflict between the state government and the constitutional head of that state, which is the governor, who will be appointed by the central government to uphold the unity and integrity of the nation, because there is a necessity of the office of the governor as the constitutional head of the state. Otherwise, the state may get detached from the Union of India. Now, how can you resolve this issue? This issue may be resolved by the interference of the highest judicial court, that is the Supreme Court of India, and that is what the Supreme Court will give a check into. Now, there was, in fact, certain important recommendations from the side of the Sarkaria Commission, which was appointed in the year of 1987, and even the Punchhi Commission. So these commissions have came forward with certain recommendation to solve this particular dispute, but these recommendations still exist in the paper, which means it has not got implementation. It has not got implemented. Now, what were the recommendations put forward by the Sarkaria Commission over the center-state dispute? Number one was the Sarkaria Commission says that reserve the bill to the President of India only in case if there is a grave threat to the Constitution of India. Otherwise, the governor should provide approval for the bill that is passed by the state legislature. And in case if the bill is reserved by the governor to the President of India, the President will have to respond within 6 months. And if the President will have to withhold the assent of the state bill or assent for the state bill, the President will have to convey the matter to the respective state legislature. This will, in a way, make efficient state legislative process once again, so that the state legislature would rectify the mistake and pass it back to the approval of the President of India. So these were the recommendations put forward by the Sarkaria Commission in 1987. Even the Punchhi Commission has said that the governor should not indefinitely delay the bill. The governor should take the decision within 6 months period, and that will not violate the right of the people of that particular state, giving the mandate to the state legislature to frame law for their well-being. Now, as I have already told you, these are the recommendations put forward by two commissions, that is Sarkaria Commission and the Punchhi Commission, and still remaining in the piece of paper. Now, how can we have a conclusion to this particular issue is through the judicial interference or through the judicial intervention. So this is possibly what we are expecting from the side of judiciary, and possibly we would be able to discuss the judgment of the Supreme Court in the coming explainer video session. So till then, it's goodbye.